Thanks for staying with us. So last week, the nation's political landscape was thrown into serious arguments following the disqualification of APC's David Leon and his running mate. This judgment was by the Supreme Court in less than 24 hours before his scheduled inauguration as the governor and deputy governor of Bayelsa State. Now, join us on the show are two lawyers. We have first lawyer Kabir Akingbolu, while in Abuja we have Liborous Oshoma. Welcome, gentlemen, to the show.
Thank you.
So we have the for and against team. In your view as a lawyer, how do you understand this judgment?
Well, you see, before we can go into the judgment, we have to analyze, we have to get the background information, the background facts. Without that, there is no how anybody can convince anybody. Actually, the judgment, well, I agree with the Supreme Court to an extent, but I don't agree with their conclusion. Now, this case, that's why I brought some, the facts are that the PDP and their candidates went to court to challenge the APC deputy governor to say, okay, you didn't meet the requirement of the district by the form, that's what they call Form CF01, which you file with INEC. They call it particulars of, personal particulars of the candidates. Now, you submit it to say, oh, these are the schools I attended. Now, in the one submitted, the name on the form is Bio Barakuma Degi Eremenyo. That is Degi Eremenyo in compound word. Now, that is the name with INEC. Now, the school living certificate, the first school living certificate issued in 1976 was Degi Bio Baraga.
Swapped.
That is swapped.
So the point is obviously the discrepancy.
Now, there was discrepancy. You need to get
so obviously.
Now, there are about 13 names of 14. Now, with all this, the people now filed an action to say, okay, with all these discrepancies in names, can we now say this is the form filled by this candidate to INEC, submitted by this candidate to INEC? Now, can we say with precision or certainty that this person who is contesting is the person who owns all these certificates? And the court made the findings to Steve that, well, you are using affidavit. Can you use an affidavit to correct your name or your certificates? That is only work or the university or everywhere that can correct the name. But you are using affidavit to say, oh, this is not my name, this is my name, and all that. That is the question before the court, and the court agreed that it is not possible.
If you look at subsection 9 of that section, where a political party fails to comply with the provisions of this act in the conduct of its primaries, its candidate for election shall not be included in the election for particular position in issues. And so that is the foundation of pre-election matters. And so if you now go to section 187, subsection 1, with your permission quickly, I read. In any election to which the foregoing provisions of this part of this chapter relate, a candidate for the office of the governor shall not be deemed to have been validly nominated. Validly nominated. That's the operating word. For such office, unless he nominates another candidate as his associate for his running for the office of the governor, who is to occupy the office of deputy governor, and that candidate shall be deemed to have been duly elected to the office of deputy governor if the candidate who nominated him is duly elected as governor in accordance with the said provision. So the two operating words here are validly nominated and unless he nominates. And so basically we have laws. Our laws laid down the guidelines to follow, the requirement that must be complied with for elective offices. And so to that extent, if you look at section 87 sub 9, it says you must comply with the provisions of the law for your name to be included on the ballot. And if your name is included in the ballot, pending determination of a matter, and the court, initially before now, section 140, subsection 1 and 2 and 3, had removed the powers of the court to remove a candidate. But Justice Kolawole, as far back as 2015 or so, invalidated that section and said, you know what, it removes the powers of the court, and reinstated the powers of the court to sack a candidate. All that said, what we should actually be discussing or be proposing is that pre-election matters and election matters should be decided. Pre-election matters should be decided even before election. And election matters should be decided before swearing in. This idea of breeding sentiment or the fact that at the end of the day, the people decide this is the candidate we want, and then it turns out that that candidate originally was not qualified to stand for election.